Good morning, everyone. My name is Gent, and I'm a partner in Cummings & Lockwood's private clients group in the Greenwich office. This morning, I'm going to be giving you an update on the federal and state gift tax laws for 2025 and 2026. As likely all of you know, tax legislation enacted in 2017 set the federal estate and gift tax exemption at $10 million indexed for inflation for 2018 through 2025. For gifts made on or after January 1, 2025, the gift tax exemption will shield from gift tax the first $13,990,000 of taxable gifts made during a donor's lifetime that do not qualify for the annual exclusion. For decedents who die in 2025, the estate tax exemption is currently $13,990,000, reduced by any gift tax exemption used during lifetime. The generation skipping transfer tax, also known as GST tax, is also $13.999 million exemption in 2025. The maximum estate, gift, and GST tax rates have been set at 40%. Under the One Big Beautiful Bill Act, signed in July 2025, as I'm sure everyone has heard, the federal estate, gift, and GST exemptions are set at $15 million for decedents who die in 2026. This amount will be indexed for inflation going forward, and my partner Eva will be talking to you about the other major changes of the Act following my presentation. The increase in the federal estate and gift tax exemptions equates to an increase of $1,010,000 per individual and an increase of $2,020,000 per married couple from 2025. The value of gifts made to any person that are not included in the total amount of taxable gifts, also known as the annual exclusion gifts, is $19,000 in 2025 and will remain $19,000 for 2026. The gifts made to non-citizen spouse that are not included in the total amount of taxable gifts for the calendar year of 2026 is $194,000, which is an increase of $4,000 from 2025. Portability allows a surviving spouse to elect to save the deceased spouse's remaining unused federal estate tax exemption for the surviving spouse's future use. Currently, only a few states allow portability of the state estate tax. Unfortunately, Connecticut, New York, and Massachusetts are not one of those states. There are several important practice notes to keep in mind when it comes to portability. State estate tax may actually be increased by relying solely on portability. Estate planning is needed to prevent such state exemptions from being wasted. For example, in Connecticut is a use it or lose it state, which means that if the exemption is not used by the first spouse, the exemption is lost completely. So you may end up paying more Connecticut estate tax in the future. That's a problem. This is where your friendly estate planning attorney at Cummings & Lockwood can help you plan around this. Keep in mind that the GST tax exemption is not portable. It's important to note that the exemption transferred to the surviving spouse under the portability regime is no longer available if that surviving spouse remarries and that second spouse also predeceases the surviving spouse. Last but certainly not least, the most important rule with regard to portability is that the portability election can only be made by filing a federal estate tax return. It's extremely important to keep that in mind, especially for those estates that don't otherwise have to file a federal return. So you need to keep that in mind for all estates going forward with a surviving spouse, that if you want to elect for portability, you must file that federal estate tax return. Thanks to the IRS's revenue procedure in 2022-32, a portability only return can now be filed anytime on or before the 5th anniversary of a decedent's death. As most of you know, Connecticut is the only state that has a gift tax. In 2025, the Connecticut gift tax exemption exempts from tax the first $13,990,000 of taxable gifts made over a donor's lifetime that do not qualify for the annual exclusion gifts. It is scheduled to match the federal exemption going forward, which means it will increase to $15 million starting January 1st. In 2025, the Connecticut estate tax exemption is also $13,990,000, reduced by any gift tax exemption used during lifetime. The Connecticut estate tax exemption is scheduled to match the federal exemption going forward, so it will be $15 million beginning on January 1st. The gift and estate tax rate is a flat 12%. New York has an estate tax exemption of $7,160,000 for decedents who die after January 1, 2025. The adjustment for 2026 has not yet been released. This is normal. New York typically releases the amount toward the end of December and even sometimes the beginning of January. And just like the federal estate tax exemption, the New York exemption is indexed for inflation. The top New York estate tax rate is 16%. The top rate only applies when New York taxable estate is over $10,100,000, and estates that are below that amount are subject to tax at graduated rates. The New York clawback. New York does not have a gift tax. However, gifts made within 3 years of the decedent's date of death are brought back into the estate for purposes of calculating the New York estate tax. This is often referred to as the clawback. The clawback was designed to prevent wealthy New York individuals from making gifts right before their death to avoid New York estate tax. Essentially, because there's no New York gift tax, there's a large trend for very large deathbed gifts, and the clawback was implemented to combat this. While making these gifts is still a very effective planning technique to transfer wealth, you and your client should be conscious of their age and health prior to advising them of making these gifts, and care must be taken to explain the ramifications if the client does die within 3 years of making those large gifts. This law is actually due to sunset at the end of this year. We anticipate we'll hear more on this in the new year. Typically, they're a little tardy in updating this, but this will be either, we think, extended or made permanent. There was a budget proposal back in May of 25, which included making the clawback permanent. There's not a ton of traction there, but anticipate this will be coming up in the spring again. So stay tuned for more on this. We'll be sure to include updates on our LinkedIn, our website, our email blast, just to keep everyone posted on it. The New York exemption is effectively phased out for estates that exceed the exemption amount by more than $5,000. In 2025, that amount is $7,518,000. So this means that for estates that exceed that amount, the entire estate is subject to New York estate tax, losing the benefit of the New York exemption. This is often referred to as the New York estate tax cliff. If the value of the estate exceeds the New York exemption by less than that 5%, so basically estates between 7.16 and 7.518, the decedent's estate does not lose the entire benefit, but they are subject to estate tax of in between those two figures. In certain circumstances where a client may be subject to the New York estate tax cliff, you may want to consider adding a Santa Clause provision to the estate planning documents. The Santa Clause is a conditional bequest in a will or irrevocable trust to a charity that will only happen if the estate is valued over a certain amount, the New York estate tax cliff amount. Note that the Santa Clause is not a one-size-fits-all solution. It's very client-specific, so careful consideration should be made, an analysis of the client's financial circumstances before proposing this approach. There is proposed legislation to remove the cliff and increase the New York exemption amount. Again, these bills don't appear to be gaining much traction. It does not mean that in the future this will not come to fruition, though. Last but not least, Massachusetts. In October 2023, the Massachusetts governor signed a tax relief package into law that increased the exemption to $2 million, as well as making changes to how the Massachusetts estate tax is calculated. Previously in Massachusetts, they had an estate tax cliff much like New York, where the decedent's estate was valued at over $1 million. The decedent lost the benefit of the entire exemption. The new law, however, in 2023, which again was retroactive, got rid of the Massachusetts estate tax cliff. So now decedent's estate will benefit from the entire $2 million exemption, which is not as high as I'm sure many would like it to be, but it is better than the use it or lose it $1 million. So this concludes your 2025-2026 estate and gift tax update.